Hello and welcome back, students. So in our last class we understood the modes of recognition. It was the temporary and the permanent recognition. So today we will understand what are the similarities between this temporary and permanently recognizing a state. Was there not sufficient to have only one permanent recognition granted? So we will understand that, and we will understand the differences between these two. So, in the views of opinion, both are indistinguishable. Both the temporary and the permanent recognition are one and the same in terms of legislative and other internal measures of a government that is going to be recognized. So, but in terms of legal incidents happened these days in terms of this recognition, there are certain differences between these two modes. But in Luther versus James Sagur Company, it was held that there is no any such difference. So again, there are certain immunities provided by the recognizing state, and there are certain international responsibilities of these recognizing states. So it remains the same for both de facto and de jure government. And there is an case, the Arantzazu Medi case. It is an English case in which there were two different governments. One was the de facto and the another was permanent government. There were jurisdictional immunities provided to de jure government in terms of that jurisdiction. It might be a civil or a criminal jurisdiction. So there was no difference shown in these two different modes of recognition. So there are two cases that can be referred for stating that these two modes recognition is indistinguishable. That is the Luther versus Sagar and the Arantzazu Mendicates. Again, again it is similar for both this de facto and the permanently recognized state. uh, the it is having a retroactive operation. So whatever transactions, even if it is the government which is not presently in power, but the another political party which is in power is getting recognized, even the governments which had their earlier contracts, agreements, treaties, that will also be recognized. So there is no difference between de jure and de facto recognition. One material difference is that in terms of diplomatic envoys, that is the relationship. In terms of politically, you can say in terms of permanently recognition, you cannot have political influence or political behavior because you have given the recognition permanently. But in terms of de facto, that is temporary recognition, there can be certain conditions to be fulfilled for the benefit of the recognizing state. That is a separate topic, that is conditional recognition, which is not accredited or which is not accepted by international community, so it is not having much relevance. So it is stated that it is one and the same, both the recognition are one and the same. In the English court, since all the countries in the world doesn't have a similar view, but English courts follow the ruling that both de facto and this permanent recognition, both these modes are one and the same. They have stated in these two cases, Bank of Ethiopia versus National Bank of Egypt and Ligauri, and the Arantzazu Mendy case. So it was as per the English courts. So why was there a reason to have a two different kinds of recognition? That is, firstly giving a temporary recognition and then later uh, there is a permanent recognition provided. The two reasons are: first reason was stated that it is a necessary legal expedient or it is a procedure that has to be followed. That first you have to give a chance to understand and get acknowledged the internal and external political behavior or status of that state which is going to get recognized. And the another reason was given was it is just a purely political character to get the work done for the benefit of of the recognizing state. So let's understand what are the procedures that made it necessary to have uh, this procedure, this de facto, that is temporary recognition, to have it a legal expedient procedure. So The recognition de facto may have a substantial function to perform in the field of international law for states. It is stated that it is a procedure in the field of international law. It can have an option of recognizing or withholding of a new government as well. You cannot say anything about a government. Is it recognized or it is following the prescribed procedures to be a proper government? So it needs to have some acknowledgement about the political character of that government. So by recognizing a state or a government temporarily, the recognizing state is enabled to acknowledge the external facts of political power and protect its interests, its trade and citizens without committing itself to condoning illegalities or irregularities in the future in the emergence of the de facto state or government. So there is no emergency to give it a permanent recognition. So in this regard, this recognition de facto is probably a necessary legal expedient. So why there is another view by all the writers, authors saying that it is just a political character to give a temporary recognition, and after having some conditional requirements fulfilled, a permanent recognition is provided. So what are the reasons? The below differences between de facto and de jure recognition make it clear that the distinction between these two is of a purely political nature. So we will go through the differences between these two, de facto and de jure recognition. The first is the official visits to and official dealings with the state in relation to its additional territory, which has been recognized de facto, may be kept to a minimum or avoided altogether. It can be a reason that the recognizing state may be having some expectations from the state which is getting recognized by it. That is, it may offer certain obligations, which may offer to the recognizing state certain obligations that it will fulfill, or maybe in any other terms. So it has stated that the official visits and official dealings are to a minimum or avoided altogether. If it is going to recognize permanently, there can be official visits and official dealings, but in this case the incidents proved that there is a minimum or altogether avoided instances of having official visits and official dealings. Again, in de facto recognition being of provisional, that is temporary character, can be withdrawn on several grounds. Excuses are there for providing permanent recognition other than those justifying a withdrawal of de jure recognition. So there can be some conditions. Again, it says that if a permanent recognition is granted, then there is no chance of withdrawing it. But if it is given a temporary recognition, they can withdraw it back. So this is again a political reason. Again, while full diplomatic relations cannot be established with this temporary recognition, it can be done so only when they recognized permanently. So according to the practice of some countries including the UK, de facto recognition does not, has a rule, being about full diplomatic intercourse. But for a few countries doesn't have full diplomatic relations with the temporarily recognized states. The next difference is the representatives of the de facto recognized states do not enjoy diplomatic immunities within the territory of recognizing state. So the these representatives of de facto recognized states do not enjoy these immunities. They should have enjoyed it, because since most of the authors have stated that there is no difference between the de facto and de jure recognition. However, the practice of states in this regard is not uniform. Some states practice it and some states doesn't. The United States practice representatives of government recognized de facto enjoy diplomatic immunities. So the another point is, while the de jure recognized state or the government which is recognized temporarily can which is recognized permanently can claim to receive the state property locally situated in the territory of recognizing state, but the state which has temporarily recognized or not given this claim fulfilled, that is, where a certain property of another state situated within the territory has been claimed, if both by the permanent and by the temporary governments, the claim of the permanent government will be considered and the claim of the temporary government will normally be ignored. So to conclude, as per the differences, we concluded that it is a political character of having two different modes of recognition. Though legal consequences follow for non-recognition of either it be a permanent or temporarily recognition, but there are legal consequences if it is not recognized. Majority of the jurists agree that so far as legal effects are concerned, there is hardly any distinction between these two modes of recognition. If at all there is any difference, it is chiefly political rather than legal. The consequence is that the importance of distinction between the two has been diminished and it is hardly relevant. So this was about the differences and the similarities of the two different modes of recognition. So thank you.